humor and a sense of humility. So good for him.
All right, good morning and welcome to an oral argument session of the 5th District Court of Appeal. My name is Rand Wallace and I will be presiding here today. Joining me on this panel is Judge Jay Cohen from Orange County and Judge Jim Edwards from Seminole County. We have one case on the docket here at 9 o'clock. It's James Zaleski versus Jonathan Robles et al. And I am going to assume that the appellant would like 5 minutes of rebuttal unless, Mr. Rigby, you tell me differently. And with that, I will turn it over to Mr. Rigby. You may proceed.
May it please the court. Good morning. This is Barry Rigby. I'm counsel for the appellant, James A. Zaleski. And Your Honor correctly stated the general style of the case, but of course we're here today because of an appeal taken from rulings relating to Christine Bucilli. You know from the background of the case that at material times she was the wife of the appellant. She resided in a home in Orange County that was subject of a fire. He primarily resided in New Jersey where he has a business. But this is about Christine Bucilli today with, we believe, related tangential issues relating to her insurance.
And Mr. Rigby, the issue really is fairly narrow, and that is whether the offer of judgment was made in good faith, correct?
Well, yes. Was it in good faith, and was it sufficiently ambiguous that it was reasonably rejected or declined?
All right, well, let's start with the good faith aspect of it. Why don't you explain your burden on appeal in terms of the good faith analysis?
Yeah, I can't tell you that I know whether that burden is mine or not, but if it is mine, and this is an issue subject to de novo review as to the ambiguity of it, what we would show to the court is it was a $100 offer, and that money sitting in the divorce court, the $86,000, that was fire proceeds paid by the insurer as a result of the fire. We think clearly that the proposal for settlement, had it been accepted, would have meant that Mr. Zaleski, who was pro se at the time, would have pinned himself in to take $100 that then could have been used to say, you released a claim to all these proceeds in a family court for $100. How can that be in good faith? Saying that he gives up any claim to that, not being able to litigate that. Now, as you know, the litigation, ultimately, he wasn't very successful in the family court in getting that. But we think that right there on its face carries his burden of proof to show on the amount versus what he was potentially giving up. It was not in good faith.
Well, in the insurance case, which is the case that's before us, the theory of liability seems to be that the appellee had some duty. This involved the installation of an air conditioner that caught fire while the appellee was within the home, and that she had a duty, a legal duty, apparently, to leave the home and put out the fire with risk to herself and other occupants of the house in order to protect the things, assets of your client. That is effectively a simplification perhaps, but in the gist of the legal theory that your client maintained against her. Is that right?
No, sir. I can't, respectfully, I have to disagree with that. And I'm going to say that it's a simplification, but it's somewhat an exaggeration based on the way that defense counsel has cast this matter. The essence of this was based on the deposition testimony and discovery that was never concluded, which you know is an ongoing issue we've raised. that it was clearly it coming from the air handler, and the evidence could have showed, and it may still show through depositions of experts for other defendants, that had she simply turned off the air conditioning, flipped a switch on thermostat and walked out, it would have mitigated damages tremendously. Simply analogous to if you have a sprinkler head break and you've got water spewing up in your yard, most people know you turn off the water. The theory is simply that there are a number of ways that she potentially could have mitigated in anticipation that the defendants found liable for the defective aspect, still to be determined in the case, installation, manufacture, any combination of the above may have raised that issue.
None of those address her liability, and this is an issue because it's you've sued everybody. You've sued the the manufacturer, you've sued the the installer. You've sued those folks, and have an arguable claim against those folks. But the focus of this case was his claim against his wife. They weren't living together, but they were still married at the time. It's his claim against her for some duty that she owed to him to protect stuff.
Yes,
Mr.
sir.
Rigby, Mr. Rigby, I'm going to interrupt you here. Was there an appeal taken from the summary judgment itself?
No, in our contention.
Well, then let's talk about this is all about attorney's fees today, right?
It's about the proposal for settlement and entitlement to attorney's fees and the amount of attorney's fees.
All right. So let's not talk about sprinklers and all the rest of that, because liability's been determined between your clients, and we're just here about attorney's fees. Let's focus on the attorney's fees and get down to that. The attorney's fees and proposal for settlement.
Well, we would want to focus the court on the proposal for settlement first. Again, it would have released all claims against Ms. Buccilli arising out of this incident, the fire, as well as her insurer. And as I've indicated previously, the record shows there was $86,000, that may be a round number, in the registry of the court that were insurance proceeds paid. That proposal for settlement for $100 could have been, it's speculative, we don't know, but it could have been used to release his claim to any share of those proceeds. And as is in the record, he contends that the way that the insurer acquired the HVAC to be used for evidence is an issue that may give rise to a claim as well, and that would have released those. So we say the proposal for settlement is not just not in good faith, but it's vague and ambiguous. It was reasonably rejected. There never should have been an entitlement to the fees. Some of those issues are more clearly articulated in the motion for rehearing after the initial entitlement hearing took place. But on the face of the proposal for settlement, clearly for $100, he gave up any claim to any of those proceeds, as well as the insurer, for anything they may have done. And his contention as to the insurer and why there's potential claim there is probably worth talking about. But I mean, I'm understanding, Judge Edwards, you don't want to get too far afield.
Well, let me ask you this. The proposal for settlement had something very innovative, perhaps. May have been copied from somebody else. That happens with the evolution of legal documents, but there was in essence an anti-ambiguity provision in there that if plaintiff had any question about the meaning of the proposal for settlement, the proposal for settlement itself invited inquiry so that any ambiguity could be cleared up. Do you know if your client took advantage of that at any time?
I don't know that he did. I know that he was pro se. He had regular communications with counsel for Ms. Buccilli, but he was also pro se at that time trying to deal with multiple defense counsel. I think he was a bit overwhelmed, and
there's nothing of record that he took advantage of that anti-ambiguity provision, is there?
There is nothing in the record that shows he did.
And I'm not sure whether he has to or not, but like I said, there's the ambiguity and concerns that you're expressing now it seems to me that the proposal for settlement itself invited, if you had any question, if you have any doubt, if you have any concerns, if something's not clear, get in touch and we'll see if we can't clear it up. Which, again, I don't know the ultimate legal effect of that, but it doesn't seem that that invitation was accepted by your client, at least of record. So go ahead.
So that just shifting to the amount of fees, we think they're unreasonable and clearly excessive, even in light of the testimony that took place before Judge Strawbridge. If you review the docket, what you will see is Mr. Bucilli's counsel, Trevor Rhodes, basically led the charge for all defendants in the case. His activity, and he's got claims for Ms. Bucilli against other defendants, which he says are necessary somehow to protect against Mr. Zaleski. It outweighs other counsel's efforts all put together. He has done more in this case than all of the other defense counsel. On the face of it, clearly those fees are not tied to what he had to do relating to Ms. Bucilli. We think those are clearly excessive, and there should be a remand for further.
I think Mr. Rigby froze up. We'll wait.
All right. Yeah, why don't we try to get a hold of him by phone?
We'll take care of it, Judge.
Proceedings. As you know, we wanted some additional time. And
Mr. Rigby,
you froze up a little bit there, probably, I don't know, it was a better part of a minute, maybe.
I think I heard you as soon as that happened, and I quit talking, so I don't believe you missed anything. But on the point of the amount of fees was the last point I made, that you can review the docket and you can see that Mr. Rhodes was litigating for everyone just about in the case on the defense side. Glancing at a couple of notes, Matt, have a minute here.
Yes.
In general, the underlying policy of a proposal for settlement is to resolve claims. That goes to the good faith issue. $100 potentially to give up claim for $86,000 insurance proceeds.
well, I don't know, but that's really kind of an issue. The $100 to give up the claim that he brought against her. And that's, and that is somewhat problematical for me. And that's why I started with my analysis that the claim that he brought against her is what's got him in this position, not the claim that he brought for the proceeds and the claim that he brought against the manufacturer or the installer of the air conditioning unit. It's the claim that he brought against his wife that's got us here.
May I have a little bit of indulgence to elaborate on that? I know we want to stay focused, but I'm certainly going to be good on time. As to some of the defendants, there's a lot of discovery still at this point outstanding. We've been consumed with this aspect of the case. But I will pose a question. What happens? It's rhetorical. If, for example, DMAC, the installer, has an expert that says this was a slow spreading fire. Anybody in the house had 30 minutes before they were in jeopardy when they could have mitigated damages, and that flips back on the person in the house. That Mr. Zaleski's claim against that person has just been potentially dramatically altered by that issue, and the person in the house there is Ms. Bucilli. Again, we complained that discovery was not completed at the time the summary judgment was entered, but Mr. Zaleski has claimed repeatedly that had he simply gotten what he was promised by her insurer, an expert report, that may have absolved her completely, and she would have walked away early in the case, but they didn't do that either. And we think that goes to that unclean hands aspect that we raised in the brief that counsel will beat me up on here today. But if they had simply given discovery and given the expert report, perhaps that would have said, no, there's nothing she could have done, but they didn't do that. But instead, they worked the case very aggressively after this proposal for settlement for minimal money, and then got the fee award. And we're asking the court to upend that. That is simply wrong as a matter of equity. I know we're in a court of law, but for them to not turn over evidence to exonerate their insured and then work it to this degree, that can't be the purpose of the proposal for settlement. The proposal for settlement is to encourage resolution. They went exactly opposite from that.
You can't conflate the actions of other parties with her liability and conduct.
Your Honor, we can't, but when that proposal for settlement provides a release to her insurer, his rejection of that is rendered reasonable, and they shouldn't be able to get fees based on it. If the insurer wasn't in there and that proposal for settlement or release, we wouldn't be having this part of this discussion.
So given the provision that Judge Edwards had mentioned earlier, why shouldn't there be some obligation on your client to go back and say, well, I'm not going to sign this if it releases the insurer, or strike through the insurer in the release?
I don't have an answer to that. I'm not going to make up an answer to that. It's just that we're talking about a pro se litigant against a small army of defense attorneys, and what he felt capable of doing and what would be the outcome. It may have been simply a lack of confidence and trust. I don't know.
All right.
But can you put that burden on a party? So many aspects of the law on this take a fairly strict construction, and our position would be adding that language into a proposal for settlement outside the rule, outside the statute. That's going a little too far afield, and I understand, Judge Edwards, that's an excellent question. I mean, I've thought that myself, but in the scheme of things, we're dealing with areas of the law that there are some strict construction aspects, and that would be stepping beyond that a little bit.
And Mr. Rigby, you're into your rebuttal. If you want to reserve the rest of your time, it's up to you.
I will go ahead and reserve the rest of this. I don't know that I'll have much rebuttal. Thank you very much for hearing me out here so far.
Okay. And counsel, you may proceed.
Good morning, and may it please the court. Sarah Lalu Amin on behalf of the appellee, Christine Bucilli. This appeal started as a two-part challenge to the summary judgment entered for my client and to the fee judgment in her favor based on a proposal for settlement that she served. We moved to dismiss as to the first part because that issue was resolved in a partial final judgment, as your honors have noted, and Mr. Zaleski didn't timely appeal that ruling. And I bring that up here because, again, as your honors have noted, there is a lot of background noise, so to speak, in this appeal, which is really on a very limited issue, and the issues are very straightforward. And there are essentially three issues here. First, Mr. Zaleski argues the trial court erred in holding that the proposal was unambiguous. Second, he argues the court abused its discretion in deeming the amount of the offer reasonable, although he wasn't too certain of the standard. That standard is abuse of discretion. And third, he argues the court abused its discretion in setting the amount of fees and costs Ms. Bucilli was awarded. So when it comes to ambiguity, the Florida Supreme Court has recognized it's not the elimination of any possible ambiguity that's required. What's required is that the offer has to be capable of evaluation by the offeree so that the offeree can make an informed decision to accept or not.
What about the inclusion of the insurer in the offer of judgment?
Sure. So, offers can certainly contain non-monetary conditions, and a release is a non-monetary condition. And releases, therefore, they have to be unambiguous as well. And so as to that issue, on page 1022 of the record, that's where releasee is defined. And as your honor noted, it's Christine Bucilli, her heirs, personal representatives, parent entities, subsidiaries, affiliate entities, stockholders, assigns, and their insurer, hereinafter the releasee. And Mr. Zaleski candidly acknowledges in his brief that the release of an insurer is allowed under Florida law. And we've cited case law to that effect, Board of Trustees v. Bowman. But he argues that general rules shouldn't apply here because he later sued the insurer. But Ms. Bucilli isn't held to that future version of the facts. She's held to the version of the facts as they existed at the time of her proposal. And at that time, there were no claims pending. The record makes that very clear, and we've cited to all of the components that are at play here, because again, there are a lot of moving parts, and we've played all that out in the brief to show, to illustrate that those proceedings hadn't been initiated at that point. But this is ultimately a moot point.
They certainly could have been anticipated. I mean, it's not a shocking turn of events that he would ultimately bring a claim against the insurance company.
Well, Your Honor, possibly that claims were, addressed to pretty much everyone. I mean, that certainly, to the extent that anything can be expected in litigation, right? But the law does provide, that's going to always be the case. And the law does provide that this is a common term. This is a common release term.
All right. Your position then becomes that the $100 clears the insurance company, right?
Yes, Your Honor, as to this claim. And at the time on the record,
It's the only claim we care about.
Exactly, Your Honor. As to this claim, and I say as to this claim because, again, the court registry deposit, I want to speak to that briefly because that was raised in argument at pages 38, 76 to 77 of the record. That was discussed at the hearing, and the court found that issue wasn't implicated at all because it found that this release is narrowly tailored to this particular case, to this particular claim. So,
Counsel,
yes.
In terms of what it's limited to, it's from any obligation, liability, or responsibility arising out of the incident which occurred, which is described in the complaint. It's not limited to the claims in the amended complaint. That would be different. It's any responsibility, liability, or obligation arising out of the incident which occurred, including when you add the insurance company in there, their obligations under any insurance contract. And they don't have to be sued. And whether it's foreseeable or not, let's put it this way. It was foreseeable enough that y'all threw it into the proposal for settlement. So therefore, you thought it was foreseeable. So, Mr. Rigby does have an argument there that for $100, he's releasing the insurance company. I mean, clearly, if you can kind of anticipate that if he accepted and later sued the insurance company might point out the language in the release.
Certainly, Your Honor, and there's no dispute about that. The release says what it says, and there's no ambiguity about it. And that's really what this comes down to, however, because this is preserved in the context of not some unenforceability or unconscionable or some type of argument like that. In a good faith type of argument that would be, a discretionary type of thing. This is an ambiguity argument, and it's not ambiguous. And the case law provides.
No, I agree. It's not ambiguous. Under the release, a very reasonable reading of it is, for $100, you give up your claim against the insurance company. Period. And if it's that clear, why would it be in good faith?
Well, Your Honor, that wasn't the nature of the challenges to this particular issue. The nature of the challenge here was that it created an ambiguity. And so that was the argument that was presented by Mr. Zaleski, was that does this operate to release my other claims? It's very clear as to what it operates to release and what it doesn't. And so in that regard, the only
how can a release, that ends the insurance company's responsibility for a major fire for $100 be in good faith?
Your Honor, I want to be clear, and so the release is as to Ms. Bucilli, it's as to the claim against her. So,
I don't, that's the whole point of this discussion, is it goes beyond that. That release appears to encompass the insurance company. And isn't that the position that's been taken in subsequently in this case?
There is a separate issue with Nationwide, and that's beyond the scope of the record. But as far as the release goes, this is a release as to the claim against Ms. Bucilli. And so
I just don't think we can look at it through that lens. We have to look at this through the lens that that this release would encompass the insurance company, as you've conceded during oral argument that it would.
Well, that's why I wanted to be clear and clarify. This is limited to the claim against Ms. Bucilli. And so
you'll have to show me where that language is in the release, because I'm not seeing it. I know how it could have been put in. It could have been put in for her liability, responsibility, et cetera, only. And to the extent any of that's insured, releasing the insurance company and all the successors, heirs, and all the rest of that. But this releases everybody for any obligation, responsibility, or liability arising out of the incident. Arguably, when there's an insurance company insuring property and there's a fire, that's often covered, and therefore they have an obligation to investigate, adjust, and pay. And for $100, I don't know whether he was a beneficiary under the policy, either directly or indirectly, and it's not part of the record. But you're asking him to release claims against the insurance company. The agreement could have been, the proposal could have been drafted tightly to say only for her responsibility. Instead, it was drafted more expansively. And I agree on the $100 for her liability, turning her into a fireman or a air conditioning engineer. I think everybody kind of agrees with the trial judge that there's no such duty. But when you're letting the insurance company off the hook by the language of the release, that's what at least Judge Cohen and I have some difficulty swallowing that. So.
Understood, Your Honor. And the case law that's cited in our brief on this point distinguishes where there are separate claims. And so a release as to one claim is not going to release separate claims that a party may have against a separate entity. And so to the
if you had phrased it in the release in terms of the claim instead of the incident, that might be more persuasive, but you didn't. It dealt with the incident, not claim.
And as to that argument, again, it's been presented in the context of an ambiguity argument. And so the notion that there is a good faith issue, the only good faith issue that was presented and preserved below was a good faith issue as to the amount of the proposal. And so the idea that this argument was presented in the ambiguity context, that this language made it ambiguous, and it does not make it ambiguous under the law.
Okay, so to follow up on that, what I hear you say is that it's absolutely unambiguous that this release includes the insurance company, right?
It includes the insurance company as this
for
claim.
$100. So he waives on this fire of the home. He, under this release, he gives up all of that claim against the insurance company for $100, right?
He gives up his claim against Ms. Bucilli for not mitigating the fire.
No, he gives up the claim against the insurance company, period. It's got nothing to do with what she did or didn't do. As I agree with Judge Edwards, nobody has any heartburn with her lack of liability, her lack of a duty, put it that way, her lack of duty to go out and try to put this fire out to protect his stuff. But it's another thing to say, well, for $100, the insurance company is off the hook. Who hired the lawyer for her?
It's an appointed lawyer, Your Honor. Yes, and that's in the record.
By who pays for that lawyer?
By the insurer.
Okay. The insurance company pays for her lawyer and puts in that release a provision that lets them off the hook for $100, right?
The insurance company doesn't do it, but yes, I understand your point, Your Honor. And the response is that, again, this is done on behalf of Ms. Buccilli. It's done with respect to, because you can't then pursue the insurance company for the claim against her once she's been released. And the way that these releases are interpreted.
It's not the claim against her that we're concerned about. It's the claim for the fire that we're concerned about. And that release would end the insurance company's liability, period. For their, this is a contract of insurance. They contracted to insure this premises and its contents against the risk of a fire. It's not her conduct. It's just the general responsibility of the insurance company for the fire.
Your Honor, the law that we cited does not, and this isn't, again, this wasn't presented in a good faith context, so it's not really on the record that way below, because the challenge wasn't really made in this way below. But if this challenge is kind of morphing on appeal into a good faith type argument, then that has to have the opportunity to be vetted out. And then, also the issues of whether the release could be construed to that effect. Certainly from my client's perspective, she is protected by this release, and claims against her insurer are protected to the extent that they relate to this. So from her perspective,
see, that's the whole ambiguity problem, and set good faith, bad faith aside, whether $100 was reasonable or not. Every time Judge Cohen and I say it releases the insurance company for everything, you always need to come back and add in only as to Ms. Buccilli. That's not what the release says. That's our problem. You see it one way, and maybe fairly so, but when 2 out of 3 judges, and I'm not trying to speak for Judge Wallace, see it as releasing the insurance company, yet you have to come back and add in that phrase that only as to Ms. Buccilli, that kind of begs the question of whether it's ambiguous, doesn't it?
Well, Your Honor, I just can't speak beyond the scope of what protects my client. However, to the extent that there is further liability, the courts have held that these types of releases are unambiguous. These types of releases are permitted. And so the question of whether it's good faith under the facts of this case is one that hasn't really been presented in that way. It's been presented as an ambiguity argument, and courts have held it's not ambiguous. And
what's
so
your best case on that?
Your Honor, let me pull up the cases that we've cited. We've cited, and we have a section in our brief where we address releases that go beyond the scope, and that's at page 24 of our answer brief. We discussed the Dryden case and the Wallen v. Tyson case of this court. And in Wallen, it distinguishes Dryden, which is relied upon by Mr. Zaleski. And it discusses limitations like we have here, where it specifies the action. And that was a finding that the trial court made below at the hearing, orally at the hearing, that this was limited at 38, 76 to 77 of the record. The trial court did find. So to the extent that we're talking about a good faith type argument, we're also talking about the abuse of discretion standard and the court finding that it was limited to this action.
For the Wallen and Dryden cases, did they include the insurance company either in the caption as a party in the case or specifically naming the insurance company in the release?
Not, I believe, in the caption of the case, Your Honor. And they were as to different parties. One's as to the insurance company. We cited the case of Bowman. And in that case, there were the 4th district addressed the question of a release that includes an insurer. And at that time, there was no pending claim. And that was relevant just as here, there were no pending claims. There was some discussion about whether evidence was going to be provided, evidence that was found in the course of the investigation. But again, this is a tenant's policy issued to Ms. Bucilli, which is also relevant here, right? So this is not a policy that's issued to Mr. Zaleski. This is a tenant's policy. So if Mr. Zaleski is to have an opportunity to kind of recast this argument in a good faith guise, as opposed to just an ambiguity guise, it has to fall under the abuse of discretion standard and implicate all of the facts of the case, and all of that becomes relevant. And again, that's not how it was argued below. It was argued strictly on an ambiguity basis, and the courts have held it's unambiguous. And so to the extent that we're going beyond that into a good faith argument, then Ms. Bucilli should have the opportunity to address that, and it would be a case of remand for those types of proceedings. And I believe Mr. Rigby alluded to that, as opposed to just a simple finding that it's ambiguous.
All right, so is the fact that it was a policy, a tenant's policy, is that in your view part of the ambiguity analysis or part of the bad faith analysis?
It's unambiguous as a matter of law, and we feel that the application of the cases on this issue provide for that. But as
what if hypothetically it hadn't been a tenant's policy? What if it had been just a standard policy on the home? Would that make homeowner's policy? Would that make a difference?
Perhaps it could, Your Honor, and that would be under the guise of a good faith analysis. And so the full context would have to be considered. And so I raised the tenant's policy issue because that's one of the things that the court would consider in the full comprehensive view of all of the evidence in deciding an issue like that on an abuse of discretion standard. And that wasn't the nature of the argument here. The nature of the argument was limited to ambiguity.
In the cases that you relied on for including insurance companies in the release, did they use a similar language that it's regarding the incident as opposed to the claims? I know you talk about those releases had the case number, your release has a case number, but in terms of the incident, I mean, that's the thing that concerns me. If you said the claims or her responsibility, his claims against her, so on and so forth, then I agree with you. Throwing in the insurer for that is permissible because the insurer's liability there would be only derivative from whatever she did or didn't do if she had a duty. But when it's the incident and all obligations, that's what I think, again, we see it one way, you see it the other way. That typically means there's an ambiguity. Not always, but
yes, Your Honor. And so in the Bowman case, for example, the release language does appear to be similar. And it's actually quite general. It's one of these from the beginning of the world to the day of these presents, and including all issues, causes, claims, counterclaims, setoffs, and allegations which were raised or could have been raised relating to or arising out of certain actions styled, etc. And so
actions meaning lawsuits or actions meaning things people do?
Certain actions styled and then the style of the case.
Laura, that's a case. At the time, I agree with you that at the time the proposal for settlement was served, the insurance company was not a defendant. And I don't even think there was a motion to amend pending at that time. So I agree with you to that extent that, it's not Ms. Bucilli's obligation to get a crystal ball out and figure what might be pled later. But again, when there is insurance and we don't know what the policy says, it's not unusual to have coverage for the property of others in a policy of insurance, and it's not before us. So that's a whole different issue. But
yeah, Your Honor,
I think I'm taking up Mr. Rigby's time now, so I'll stop.
Thank you, Your Honor. Well, I do see I'm past my time here, I believe. And so I'll briefly conclude by respectfully requesting that this court affirm. And if we are going to go beyond issues, we would respectfully request the opportunity for supplemental briefing on that particular issue. Thank you, Your Honors.
Okay, thank you, Ms. Lelu Amine. I hope I pronounced that right.
Lalu Amin. Thank you.
Yeah, you weren't even close.
Was why I was apprehensive about saying.
No,
it at the beginning,
I
yeah.
was glad you were presiding.
And Mr. Rigby, you may conclude.
You're going to have to
Can't
unmute.
interrelate.
There we go.
Can you hear me?
No.
We can,
Okay.
yes.
We can't avoid the interrelationship of the divorce case, and Ms. Buccelli's counsel filed the divorce judgment in the fire case, so it's a part of this record. But what we know is there was a dispute as to whether this was a homeowner's or a tenant policy until the divorce case was included, and the insurance company even sent one of their attorneys to testify in the divorce case. And so it was determined to be a tenant's policy, despite the fact that it says homeowner's policy at the top. So clearly there's from the get-go, there's an insurance potential dispute just on the face of this policy. But, and I know the court has a sense of this duty issue, but bear in mind, if she's a tenant for the purposes of collecting under a policy, the landlord tenant statute places duties on tenants to care for premises. We also think that her deposition testimony reflected that she took time to remove some of her own contents from the home to protect
You're
them.
going back to the liability arguments, the summary judgment. That ship has sailed. So let's focus on the proposal for settlement.
Well, Your Honor, I know that, you know, that's what we attorneys do. We persist sometimes, but thank you, and I'll get back on the summary judgment. I would direct the court, to the extent that Ms. Lalu Amin indicates that certain things weren't raised below, where certain of the insurance issues were raised and more clarity was in a motion for rehearing after the actual argument that took place before Judge Higbee. That's in the record at page 2951. Clearly, those insurance issues, the concern about what Nationwide
Did you raise them in terms of bad faith, or did you raise them in terms of ambiguity?
I believe it was more of an ambiguity issue even then. We would suggest to the court that, you know, that the ambiguity is one of those things that's always subject to de novo review. The bad faith aspect is inherent in every proposal for settlement, whether it's good faith, bad faith. And I don't know that we have to raise it below. That's always going to be part of the analysis.
Well, you better raise it below if you want to raise it here.
Well, again, we've got.
Yeah, we're a court of correction of error. And if you didn't present that argument to the trial court, even if you're right, you know, that's not our, you know, it's not our job unless we're engaged in tipsy coachman analysis.
I can't lay eyes on it today. I would have to go back through the transcript again to say that, but I'm a little bit surprised to hear that today, because we feel like it's been something that's been bantered about previously. Ultimately, the court,
I don't know what bantering about means in terms of preservation of error.
Raised in various proceedings that took place, whether it was the amount of fees, whether it was entitlement to fees, I can't tell you that as I sit here today.
All right.
Finally, back on the ambiguity, I think Judge Edwards honed in on it. What does an incident mean? And, you know, relating to, we have insurance proceeds that are sitting in a court to be fought over. The release appears that those relate to this incident. Is he releasing any claim on that? Is he releasing any claim on insurer? The ambiguity aspect of that right there has been brought out this morning. We think that's the appropriate thing for the court to focus on. It can do it under a de novo review standard, and we're asking that it be remanded for further proceedings. Thank you.
Thank you, counsel, for your argument. Case was very well argued, and we are